Hi, I'm Christopher Burgon. I own and run Christopher Burgon Solicitors. We are a specialist litigation and commercial law firm based in London. This is the fourth out of 6 videos in a series called 6 Steps for Majority Shareholders Who Want to Take Back Control of their company. First video was about general company law and who controls a private limited company, directors or shareholders. Second one was about how to get a rogue director shareholder out of the business. Third video was about protecting the company, about whether or not you would need an injunction and what that requires. This fourth video is about actually recovering your losses from the rogue director. So if the director in question has been taking money out of the business that he shouldn't have, then that is money that can be reclaimed into the business. If he has been causing losses within the business by competing against it, then again, those are losses that can be reclaimed. Being a director, we mentioned in the first video, directors are the ones that have the power to undertake the day-to-day running of the company. Directors have pretty stringent duties according to the Companies Act 2006. The main duties are to work for the success of the company and all of its shareholders, also to notify any possible conflict of interests, to use due skill, care and diligence, and only to work within their powers. So, if a director takes money out of a business without authority, then he is acting in breach of his duties as a director, and that money can be reclaimed by the company. If he is running a business in competition with the company, then obviously he's not working for the success of the business, and that is a conflict of interest which he should be declaring. Again, profits from the business, from the mirror business, can be reclaimed by the company. So those are all actions you can take against the rogue directors. If the rogue person isn't a director, if they're a substantial employee, someone that really contributes to the business at a high level, chances are that they have fiduciary duties to the company in any case. A fiduciary duty is based on a relationship of trust and confidence. For example, if you have someone who's taking care of all the marketing for the company, he will be given trust and confidence. He will be able to use his discretion in carrying out his job, and he will be providing advice and assistance to the company, and he will have fiduciary duties to the company which are very similar to directors' duties, and you can bring an action against them for that. The question is, should you be doing this? Should you be issuing court proceedings? Well, we spoke in the third video about the need to protect companies and how an injunction could be essential to doing that. So that may be one very good reason to bring a claim for damages. The other good reason is, of course, to recover the money that you've lost. But if you're going to do that, you've got to think about whether the person you're bringing the action against actually has the money to pay you. There's no point in bringing an action against someone just to end up with a judgment against them. A judgment is very useful. You can send the bailiffs around to their home, you can freeze their bank accounts, you can put a charge on any property that they own, including a house, including any shares that they own. But if they don't have any money, then a judgment is just a piece of paper. So you should also always be thinking about whether or not the person you're bringing an action against can actually pay you. And the third one is you have to do it properly. There's no point in just bringing an action for the sake of it. Of course, you won't be doing that. What you need to look at is the prospects of success of such an action. You may know that they've ripped off the company, but you need to look at whether or not you can prove it, again, about whether or not they have an arguable defense, and you need to weigh up if, in all the circumstances of a case, if you issue it, then you will be successful. But if the person who's been ripping off the company does have the money, maybe they haven't managed to get rid of it straight away, they do have the money to repay you, and you have good prospects of success, then I think bringing an action against a rogue director is a very good thing to do, not least because it will help you recover your shares. And more about that in the 5th and following video. If that's of interest to you, if you've got a rogue director that's incurred losses for the business and you'd like to know more, then please get in touch. Please go to the website, press the book a meeting button. That allows you to choose a date and time, and we will have a conversation that is absolutely free of charge, free of obligation. Alternatively, drop us a line or give us a call and we'll call you back. If you'd like to, you could leave a comment or a message in the space underneath this video and we'll be in touch.